Okay. Okay, let's see how we begin. Plus. I want to share the screen right away. Okay. Something purpose are not doing me a favor. Right. Today we're handling conflict resolution. Conflict resolution. Remember, when you're doing anything, conflict is part of life. So the question is, when you have that conflict, how do you resolve it? This is a very, very normal thing. So conflict resolution. Conflict resolution is a way for two or more parties to find a peaceful solution to a disagreement among them. This disagreement may be personal, financial, political, or emotional. When a dispute arises, often the best course of action is negotiation to resolve the disagreement. Now, we're going to go through all these, some of the things we go through in life. Conflict resolution is not going to be on specific things, but let's look at the real life experience. The first one, the first method of conflict resolution is negotiation. When you have a disagreement, how are you going to begin negotiating to see to it that this is put to rest? Let's look at the political aspect or the unlawful aspect, where we'll see rebels using the unlawful means of using guns to overthrow a settled government. The moment when they go for negotiations. So negotiation comes as the first one. So negotiation is a discussion of two or more people with a goal of reaching an agreement. The first strategy that people can use during conflict resolution is negotiation. So negotiation is an integral part of every human activity. It is a very integral part of every human activity. Then the second one is mediation. Mediation is a voluntary and confidential method of handling conflict. Mediation is a process by which participants come together with the assistance of a neutral person or persons systematically isolated disputed issues in order to develop options, consider alternatives, and reach a consequential settlement that will accommodate their needs. Now, there is one thing that I want you to always know. Under the court system, there are moments when you have conflict. Let me say there is criminal and civil. In criminal, we always have one simple thing. At times, you'll have a matter in court, and the accused person raises their hand and says, please, I want to talk to the complainant. Now, that process is called mediation. That is what we call ADR, Alternative Dispute Resolution. Alternative Dispute Resolution. So you're trying to mediate and see how best you can solve this. In civil matters, we always have what we call, we still have ADR, Alternative Dispute Resolution. Only that in civil matters now, it is mandatory. It is mandatory. When you file your plaint in court, you're supposed to also file your mediation summaries. Before the matter can commence, you're supposed to go through mediation. So during the mediation, you can always agree on a few things. That's one thing you must know. Then we have the process of arbitration. Arbitration. This is another method often used in conflict resolution. It is voluntary, binding, and final. They say final because the moment when you have either the act or the agreements that you're making, and you say the arbitrator's decision shall be binding and final. It shall be binding and final. So if it is final, you do not need to go to court. But there are moments where the contract that you've made says that arbitrator's decision shall not be final. So at that level, you have a right to go back to court where you feel you're dissatisfied with the decisions of the arbitrator. Now, in civil matters, you'll always seek for a mediator. If you have the mediator, if the both parties agree on the mediator, well and good. If you don't, court will get you a mediator. Now, even in contracts, you can always get an arbitrator where both of you parties agree that this we shall get you write in your contract and say, where there will be a conflict, the conflict shall be solved by an arbitrator who is going to be chosen by both parties, and that will be fine. So arbitration is where a dispute is settled by an award to a victor by a tribunal which gives effect to existing laws which binds the parties. I'll give you an example. When you look at your Cooperatives Act, remember we discussed cooperatives. When you look at the Cooperatives Act, it gives you a provision that disputes in cooperatives shall always be handled by an arbitrator. They do not allow you to go to court. It is only if you feel the situation is there, that is when you end up going to court. But even when you go to court, it will be called the court of arbitration. It's not like any other ordinary court. Then we have adjudication. This is the most common one. This is what most people are familiar with. Litigants or parties go to court in order to resolve conflicts and resolve disputes between them. Yes, litigation or adjudication is the process of going to court. A litigant is a person who has gone to court. Either you've sued or that you have been sued. So you become a litigant. That is why they say courts have now introduced ADR, which is alternative dispute resolution and mediation, in the process of adjudication, just like I explained it a little earlier. Then we have the process of bargaining. This allows each party to put forward its demand. It demands looking at the merits and demerits of each party. Each party seeks to exploit and exploit the values of the other side. Now, this is one simple thing that you guys must always watch out for. When you're entering into a contract and you're going to end up bargaining, the person you've gone to visit or the person you've gone to see will be in a better bargaining position. That is one thing you must know. That is why most people always want you to meet in neutral places. Never allow to go and visit somebody where you're going to bargain from, because at that level he has a better bargaining stand. And that is one thing that always causes trouble. Then we have the last proposition, which is called rend a judge. This is where parties seek assistance of a judicial officer to resolve a dispute among them. Yes. You want to resolve a dispute among yourselves. Now, rend a judge means you're not having the normal court process. You will have a dispute and you say, okay, the easiest way for us to solve this is let's look for a judge that we feel is going to be on our side, is going to be neutral. So at the end of the day, all of you will settle for, let me say, the Chief Justice. Then You agree and you say, okay, let's go and meet the Chief Justice. You get to the Chief Justice, you explain your problem to him, then he gives you a date. He tells you, okay, I'm not coming as a judge of the Supreme Court, but I'm coming as an ordinary person. So you've rent a judge. He's not coming to handle your matter as if he's a judicial officer, but he's coming to handle your matter because he's now looking at. It doesn't have that professional way of handling things. He only tells you, but please, at that level, whatever you did was wrong. This was right. But whatever you did that you think is right, please, it was hurting the other person. As simple as that. Until both of you agree on one position. Now, yeah, please. Yes. You could do, if you feel you can send a message, I have no problem. Now we're now looking at tax resolutions. How do you solve tax issues? This is governed by the URA Act and the Tax Act. Tax is Tax Appeals Tribunal Act. A tax is a compulsory financial charge or some other type of levy imposed on a taxpayer by a governmental organization in order to collectively fund government spending. Under the URA Act, all power to collect tax in Uganda is vested in the URA. That's one thing you must know. The power to collect tax is vested in URA. It collects and sends the money to what? Finance. However, where a taxpayer is not comfortable with the assessment that URA has assessed, then he can appeal to the Tax Appeals Tribunal. The Tax Appeals Tribunal. The Tax Act provides that the tribunal's aim is to settle any tax dispute and should be handled expeditiously. So tax disputes should be handled expeditiously. Remember, it's one thing that allows government plan. So if you take long handling tax issues, just like you always hear people making noise that there's case backlog in court. If the process of case backlog came to tax, then it will be very dangerous. So a taxpayer may object an assessment made by URA within 45 days after the assessment and must be written to the commissioner with the evidence showing the dissatisfaction with the tax decision. I want you to be very careful with this because the examiner always sets questions around here. The objection must be made within 45 days. So the tribunal shall be comprised of 5 members and its quorum shall be 3 members. So the tax appeals tribunal has a quorum of 5. It has 5 members, but the quorum shall be 3 members. Before a taxpayer files the complaint, before you file your complaint, the taxpayer must have paid 30% of the assessed amount. Now, we used to have that question at LDC, that what do they mean by pay first and argue later? They were insisting that you have to pay the 30% first, then you argue. So you have to look at those cases. There's the Stanbic Bank Holdings Limited versus URA, the tax appeals tribunal number 56 of 2019. There is Balondemo versus URA 2022. There is Airtel Uganda versus URA 2022. There is UETCL versus URA also 2022. Then we have the PPDA resolution. PPDA, public procurement and disposal of public assets, is governed by the PPDA Act. The PPDA Act. The Act provides for the process of administration review in procurement process. Administration review or administrative review. Administrative review is the process of handling complaints arising out of alleged breaches of the procurement law. And the administrative review is initiated when a complaint from a bidder is made, claiming to have lost or is at risk of losing a tender due to a breach of procurement law or as a result of errant actions by a procuring and disposing entity or competitors. A bidder can apply for administrative review at any stage of procurement process, but in any case within 10 days from the date when they first became aware of the circumstances giving rise to the complaint, after paying a prescribed fee. Now, tax is 45 days. Procurement is 10 days. So you have to be very careful with this.
Excuse me, sir.
Yes.
You said after they first became aware of the circumstances giving rise to the what?
It is going to be a complaint.
To
Yes. I'm going to put this right. Don't get worried. I'm going to put it right before I send it to your group. Rather than mean to send it out. Now, after you pay, you have to first pay a fee before you file your complaint. Just like at court, if you have a plaint, you first pay a fee, the court fees, before they hear your case. So just like procurement, you have to first pay that prescribed fee. So they're saying a bidder cannot apply for administrative review after a contract has been signed. So just be very, very careful with some of these things. Let the examiner not fool you. At times, he might bring your complaint after the 10 days, or he might bring the complaint after the contract has been signed. So they're telling you you cannot apply for administrative review after the contract has been signed. So a bidder requesting for administrative review must show that there has been now the aspect of paying the 30% fees is provided for under the law to avoid guys from just coming in to ask anything, because anybody can just begin doing whatever they want. They'll begin complaining, but at the end of the day, they just want to waste time, and government is not getting money, because at the end of the day, you're going to pay the money. So you show a sign that you're going to pay the money, regardless of whether it comes from your side or against you. That is the reason as to why they pay the money. So a bidder requesting for administrative review must show that there has been an omission or breach of the PPDA Act, guidelines and provisions of the standard of bidding documents or best practices by a procuring and disposing entity. PPDA. An application for administrative review should provide the name and contact of the bidder seeking review, the procurement or disposal requirement to which the complaint relates, and the grounds for the complaint. The role of PPDA in an administrative review are as follows. 1, you suspend the procurement process until the administrative review process is complete. Notify the bidders of the application and invite them to make submissions. Institute an investigation. And 3, issue a decision within 21 working days stating whether the application is upheld, reasons, and any corrective measures to be taken. So the primary remedies available under judicial review of administrative decisions in Uganda are as follows. And this is a very common question, very common. Remedies under judicial review of administrative decisions. We have certiorari. Now, certiorari, you have to go back to the notes, the introduction, and you begin looking at the Latin maxims. Both certiorari and mandamus are under that. Then we have prohibitory orders. This is given when the administrative body has not yet taken a decision, but is impending. For example, Now the prohibition orders will seem as if it is stay desist. Stay your decision that you are about to make. Because you're intending to do something. You stay it. Then we have the declaration. It only clarifies the legal position or rights of the parties involved. It does not affect the decision taken. Now we have what we call a declaratory judgment. There are times when court gives declaratory judgments. Declaratory judgments do not change anything. It will not change the status quo. It will only tell you, okay, this was your right. But that is it. But it does not mean that whoever has breached your right should be arrested. No. It is just declaring rights. Then we have injunctions. It restrains an administrative body from acting in an unlawful manner or maintain the status quo. And finally, we have damages. You know what damages are? That is a monetary compensation. So that is your position with conflict resolution. We have to look at land and what? Land and trust. Let's first finish doing trust before we do land. Trust before we do land. The people who did not still have a very big problem with the law of trust. The law of trust. The law of trust. I believe you saw Aga Khan being honored by the president. Was it yesterday or the other day? I think it's yesterday. Now, when you see Aga Khan per se is a trust. Madivani you look at Mukwano, all those are trusts. I remember telling you that I'm more comfortable dealing with the trust other than dealing with a heir. So I'm going to use heirs vis-a-vis trusts. So a trust is a relationship where the property is held by one party for the benefit of another called a beneficiary. Relationship, remember this area is fully examinable. So you have to be very, very careful. Relationship where the property is held by one party for the benefit of another called a beneficiary. I'll give you an example of persons having letters of administration. The administrator of the estate of the deceased is a trustee. That is one thing you must know. The property is not his. The property is for the beneficiaries. Though some of the administrators transfer the property into their names and end up doing whatever they want. So a trust can be created expressly by the settlor or impliedly by court or orally. This is one thing you must know. Expressly by the settlor is the person creating the trust. If you have, let me say, 5 children and property, you do not now need to say that I'm going to pick one of my kids to be the heir. You create a trust and say, I'm handing over this trust to Bank of Uganda. So Bank of Uganda is the one going to take care of your trust. The beneficiaries are your children. So you who has made the trust is the settlor. So it is made expressly by the settlor or by impliedly by court. At times when there is trouble, you run to court. The Baganda have a very interesting thing. Something that always confuses me. Tuino Mukuza. So the Mukuza will also be impliedly, if the matters go to court, impliedly a court will say the Mukuza is a trustee. Or it is made orally. You just wake up and you say, you always leave them in the hands of so and so. Now, the difference between a trust and a testamentary, a will, is that a trust is a contract. Both parties sign. The settlor signs and the trustee also sign. So it becomes a binding contract. But under a will, remember both parties only take effect upon the death of the settlor. But under a will, the moment it is only the testator who knows what he wants. The heir or any other beneficiary is not aware. So upon your death, you cannot tell him that, please, you're not allowed to sell. But you're not around, it's not a contract. I did not sign for it. So you cannot tell me I'm not allowed to sell. Automatically, I will sell. So a trust must possess the following certainties. Now, they'll always ask about these certainties. So for a trust to be there, there must be a clear intention to create the trust. There must be a clear intention to create the trust. The property subject to the trust must be clearly identified. And three, the beneficiaries of the trust must be clearly identified. A trust has two types, namely a revocable trust, which may be amended, altered, or revoked by its settlor at any time, provided the settlor is not insane, and an irrevocable trust. Now, when they say revocable trust, you can change it. You can alter it, amend it, revoke it at any time before your death and insanity. But there are those trusts that are irrevocable, just like the one for the Aga Khan. It is irrevocable. You cannot just wake up and say, now we're avoiding to put up Aga Khan hospitals, please, no. You cannot revoke that. It is an irrevocable trust. They will always ask you for the parties of a trust. In fact, most of the questions are on the duties of a trustee. This one just comes slightly somewhere, briefly. So parties of a trust. The first person is the settlor. This is the person who creates the trust, the settlor. Then you have a beneficiary. A beneficiary is a person who receives benefits from any assets the trust owns. Then you have the appointer. This is the person who can appoint or remove a trustee and is always mentioned in the trust deed. Now, the moment the trust is created, the moment the trust is created expressly by the settlor by writing a deed down, that deed always mentions the appointer. That upon my death, you'll always go to so and so. If so and so also passes, the trustee also passes on. You'll go back to so and so to appoint another trustee. So upon the death of the trustee, go to so and so to appoint another trustee. Then we have the protector. This is a person who has some control over the trustees. You will not just wake up to do anything. You will always have to consult that person, the protector. Then you have duties of a trustee. Please, the moment you fall short of any of these duties, they are going to throw you off. Now, there are times when you watch, you will redo most of your questions. And I thought, I'm thinking, we begin revision. If we finish the syllabus today, we begin revision next week. That is what I'm now looking at. So that we have enough time to do most of the things. So, duties of a trustee. The first one is the duty of care. You have to be very careful when you're handling trust business. No. The core objectives of trustees is not to make profit. It is not to make profit, but to act in the best interest of the trust. That is one thing you must know. Basically, do not wind up the trust per se, but make sure that it has to keep moving ahead, time immemorial. I might make a trust, and I'm still looking at my great-great-grandchildren. Because when you look at Madivani, it is the great-grandchildren enjoying. This guy is died long time ago. Mukwano, same. But your purpose is not to just make money, but maintain the legacy of the deceased. So two, you have a duty to act personally. Now, this is one area that they always fix students on. A duty to act personally. There are times when they tell you you're a trustee, or you have the letters of administration of somebody's estate, and the administrator goes to Harvard to study for the next 10 years. They're telling you you have a duty to act personally. Now, when you're a trustee, you cannot delegate your powers to another person. That is why they tell you have a duty to act personally. You cannot delegate your powers to another person. And it's the area the examiner always asks. Why they say you cannot delegate to another person is because of one simple thing. The principle in administrative law called delegatus non delegare. A delegate cannot delegate. So they have delegated the powers to you as a trustee. Why are you also delegating? That is why they say you act personally. So 10 years is not possible for you to be out of the country. You have a duty to avoid conflict of interest. A duty to avoid conflict of interest. Then you have a duty to be impartial. Don't say that this beneficiary, so and so, is very good. I think I will handle him better. But this one is very stubborn. He doesn't like me, so I think I'm not going to give him the benefits. You're not supposed to be impartial. You have to be a duty to be impartial. You're not supposed to be very partial. Then you have a duty of confidentiality. Don't release secrets of the trust. Then the duty of loyalty. Now, the last one is one other thing that always causes trouble. A duty to account for their actions and keep the beneficiaries informed. Now, this is where trouble begins from. You're not very careful. Most of our administrators never inform us. You will just hear one morning, he has sold the building. To do what? Nobody knows. But you're supposed to keep the beneficiaries informed. You have a duty to account for your actions. So the moment you're selling the building, come and tell the children that, please, I sold this building at this amount. And the reasons for this was because I wanted to do this. But it has to be for the benefit of the trust. And you keep the beneficiaries informed. At the end of the day, when the beneficiaries begin asking some of these questions, you find the administrators chasing them. Some are even arrested. Just today I was at court, and there was a family that was seriously weighing arms against the administrator, and the administrator had even arrested them. But he's forgetting that he has a duty to account for the actions and to keep the beneficiaries informed, because he had sold some piece of land, and the beneficiaries were asking, you've sold it as who? And he's like, please, I'm the administrator, don't ask me these questions. He forgets that it is the beneficiaries who are your bosses. So this is done. Let me now go in for land. And law. Land law. Just give me a few minutes. and law. Mm. Land law. This is a very, very interesting thing. And it's also very, very examinable. But I remember it's very common. All of us love having land. And some of the things we shall slightly get off the ordinary syllabus and begin discussing the normal usual things. So land management in Uganda is governed by the 1995 Constitution, Land Act, and the Registration of the Titles Act. These provide for the following types of tenure. We have what we call tenure, how land is managed in Uganda. The first tenure is the freehold tenure. This is where land is held in a fee simple or for life. Okay? Now, the specific areas in Uganda where you'll easily get the freehold tenure. Buganda per se, there are very few areas where you get the freehold because it goes under the mile land. I've told you land held under the customary land tenure and a leasehold can be transferred to this tenure. So if you have a land under the customary land tenure and the leasehold, these can be transferred to a freehold tenure. But for land held under the customary tenure to be transferred into a freehold tenure, the person who has bought it must abide by the customary norms of the land usage in that area. I'll give you the example. We've been seeing this whole chaos of the Balalo in Gulu or the northern Uganda. Land in northern Uganda is held under the customary land tenure. Now, to them, they were saying, please, these guys are not following our customary norms of the area. One is, even if it is custom, land, cows can be grazed on any other land. The aspect of them destroying property, yes, we shall see how best we can do it. But the unfortunate bit was that those cultural things that they always have. When a woman gives birth to about twins or something of the kind, there's something that they do specifically on the aspect of cows, which the Balaro were not going to do. There was the aspect of overkilling animals on what, which is not going to be very common with this, the Balaro. That is why there was always that conflict. But if they were doing the customary norms, there would have not been any problem. Then we have the Milo land, which is the second one. This is a tenure where land is held for life. This is mainly held in Buganda. It was established in 1900 between the British government and the Buganda government. The British government signed, if you remember, the 1900 agreement. That was the agreement that the British government gave the Kabaka of Uganda the Milo agenda. So it was now referred to as Milo land. The British colonial masters gave the Kabaka of Uganda land, which was called Milo land. Under Milo land, there is public Milo, which is held by the Kabaka himself, and private Milo, which the Kabaka gave to his subjects, and the subjects later sold some of the land. You've always seen people with the titles of Milo land, but in private hands. That is normal. The Kabaka kept giving his subjects some, and some of these people also kept selling the land. But there is what we call a public Milo. I'll give you the examples of a public Milo. The land that is housing Bulangi or Ruvili or Kasubi, Tums, that is a public Milo. Nobody can risk with it. But private Milo, you can always see these guys. And I'll always tell the guys in financial institutions, you have to always dispute the things. You have to know to differentiate between a public Milo and a private Milo. Somebody will come to borrow money and they will use the public Milo. And stupid enough, you'll give the person money. Please, at the end of the day, you'll not recover that money. And you will not take that land. You would have made a loss. And you have customary land. This is where land is held under the specific customs of different tribes in Uganda. The land is held by the community, and transfer of land is always restricted to be within the community according to the customs and usages of that custom. So that one is very, very strict. Then we have the leasehold. This is where a tenant holds a lease on the land. A lease is where a tenant holds the land for a specific period of time, e.g. 5, 20, 49 years, etc. It has chances of renewal upon expiry. Now, I want to tell you one simple thing. One of the grounds of refusing to renew a lease is where you fail on the construction. You fail on the construction agreement. They gave you a lease. Let me say it is a Pinet. You've been given a lease at Lubowa. It is for 5 years. The 5 years lapse without you even putting a brick or sand on the site, please. That lease would have expired and they will not renew it. That is according to the law. Now, if you breach the lease agreement, some of the lease agreements, still it will not be renewed. For example, you have a lease and the lessor is the person giving you the lease, the owner of the land. He says, please do not sell alcohol on my land, or do not sell pork on my land. And you both sign. After 2 years, because bars are making money and pork is one of the delicious that people are eating and making money, you decide to do that. Please, upon the expiry of your lease, you're going to be thrown away. But you must know one simple thing, that evicting a lessee or a licensee, you have to look at the construction, because you're not going to tell him to go away with whatever he has put on your land. There is a provision under the Land Act that you should not, whatever is on the land should be left on the land. So if the land has a building and my lease has expired, you're going to compensate me for this building, whether you want it or not. And that is one of the things that most people who get leases on government land do. Because at the end of the day, government feels whatever they are going to ask for compensation is always too high. So they just give him they just extend the lease. That's why you'll see some people having a 99-year-old lease. So a lease holds titles can be given out to the rest of the land tenures. So on all these land tenures, you can apply for a leasehold, whether it is freehold, milo, or customary. You can just go and say, please, give me a lease for this period of time. Non-Ugandans can only own land under this tenure, not any other tenure. So non-Ugandans only receive leases. There's one thing you must know, and URA is becoming very interesting. If you're a non-Ugandan and you buy land and you want to have that land registered, one of the grounds you need is a national ID. The moment you don't have a national ID, URA will not give you a TIN. So you bought the land, but it is going to be in suspense. So at the end of the day, they will give you a lease. And remember, you're not a Ugandan, but you want to have these things, your children around, they'll just give you a lease. And whatever you can do is just extend, tell your children to always extend the lease upon expiry. So where the landowner decides to terminate the lease before its expiry, the landowner shall compensate the leaseholder, save for the breach of the leaseholder by the lease, e.g., failure to pay rent on unfulfillment of the lease contract. So you have to pay him if you're terminating the lease or upon its expiry. You can only not fail, you shall not only compensate him if he has not paid the lease rent or he has not fulfilled the lease contract. At that level, you note. Under the Constitution, government has the power to compulsorily acquire somebody's land under any tenure for public interest. But the owner of the land must be compensated before the takeover. Now, this is a very interesting one. That is the Constitution. That is true. But there are moments when government takes over people's land without compensating them first. And I saw recently in Parliament where these guys were making noise that you rather give them the land and compensation will come later because it is for the benefit of the community. For example, if government wants to build a stadium, it wants to build a railway station, a railway line, it wants to build a hospital, automatically they were saying, Parliament was saying, please just give them. Your compensation will come later. But at that level, it becomes very tricky. Because the moment they have the land, the compensation might not come at all. So you rather get the compensation right before the land is taken. But no one has the right to take somebody's land forcefully. So if you're seeing the way guys are taking people's land, it is not lawful, it's not allowed. A licensee is a person who is on another's land by the permission of the landowner. When the license expires and the person is a trespasser who has no rights whatsoever. Now, This is one area that I want to emphasize, and the examiner always gets you on this. Somebody comes onto your land and seeks for your permission that please give me permission. I just want to use this land to dig for some period of time, then I'll keep paying you rent. And you're like, it's okay, fine, because I'm not using it. You use it to keep the land for me. The person stays on the land. Just because you've given him the permission, he becomes a licensee. But if you stop, if your permission ceases and you say, please, I now want to use my land. Now that is the time, the period. He now becomes a trespasser. The moment he still stays on the land, he becomes a trespasser. So you'll do anything because he has no rights. Apart from the compensation of the developments he has put on your land. Now, this is the most interesting thing. I remember you saw the principle of nemo dat in the sale of goods. He who has no title cannot pass on good title. So at times, these guys also do one simple thing. They either forge the titles of the landowner and sell the land to another person. If it only moves to two people, the landowner will recover his land because it maintains the principle of nemo dat he who has no title cannot sell, pass on good title. But the moment it gets to the third person, please, you would have lost your land. You would have lost your land because it becomes the bona fide purchaser for value without notice. Two, if the trespasser keeps staying on your land and you do nothing to throw the trespasser off your land, you do not go to LCs, neither do you go to court, and the trespasser stays on your land for 11 uninterrupted years. Automatically, that land belongs to it becomes the trespasser's land. Those are some of the things you must know. I know the examiner always gets you on that, but that is the position.
Excuse me.
Yes, please.
I have the question. Yeah, I wanted to ask if there's a trespasser and they stay on that land for 11 uninterrupted years, and then they themselves abandon that land and go away for, let's say, 15 years. At what point could it be said that and then they come back, let's say after 20 years? Can they still claim that that land is theirs?
No. The moment they leave, they would have gone with their rights.
Okay.
But the moment they still stay on the land, please, that is where the game is. So, when land is transferred from one person to another, the following taxes are to be paid to URA before the transfer is effected. So the first one is stamp duty, which is it 1%? Then we have income tax, where one sells land as a business asset. Just like you see these guys of real estates. You have to pay the income tax. Then VAT in some certain circumstances, e.g. where one sells land or commercial premises with a value above the VAT threshold of 150 million shillings. Then VAT will be, it will attract VAT. So for example, you sell your building at 2 billion shillings, please, you'll have to pay VAT. So I believe we finished the syllabus. This was our last. Unless you have any other topic that you want me to handle, I have no problem. Any questions? Very welcome. Okay. You saw on the syllabus the law of agency. Unless you missed the first class, because we covered it. The law of agency was covered. That is the truth. And I told you, under the law of agency, there are only 3 things that you need to know: the types of agents, formation of agents, basically, duties and rights. Duties, rights, liabilities, and termination. Only that. Don't bother with the rest. But just know that agency stems out of the law of contract. So next week, the truth is, I think I should get, no, tomorrow I have to send all these notes to Maria. Then I'm going to get my past papers. In fact, before we do the past papers, I'll now begin giving you the question approach. Then I give you time, we look through some of these things. Then we are now getting to the real bit of it. Because at first, this is just having the material. Now we have to put the material on the paper. And that is the one area we must be very abreast with. You see, you might have the notes, but you do not know how to use the notes. But this time, I'm going to do this. We'll find time. I believe by the end of October, I would have done something relatively well. I'm still trying to see how best. Yes, I have your test. I want to see how best I can liaise up with Maria and see when we can have one. Okay. For today, let me wish you a good night.